Ohio does have legislation pending right now, House Bill 33. It hasn't seen any activity since February of 2015, but my sense is in the coming weeks there may be some reinvigorated effort to look at this. This is a very, very narrow medical marijuana piece of legislation that basically says you have to be treated at one of these specified facilities and you're being treated for epilepsy, and in those instances the parent or legal guardian of a child or the adult user would be authorized to acquire medical marijuana. There are a number of other proposals. Responsible Ohio has promised to come back. The Ohio Rights Group is going on in the 2016 election cycle. There's an organization called Ohioans to End Prohibition, and I heard just a couple days ago about a group called, it's not showing up here, Sohio, which promises to be the Wendy's of marijuana. This is as of 2 days ago. So more to look forward to. So the question marks that we have still, we tried to look at what happened in other states, and we're trying to learn from those situations so we can be best prepared. But we still have some questions around this gap between impairment and disability. Now, those of you who have unionized workplaces and have collective bargaining agreements, before you go back and decide to change all your policies, just remember that drug testing is a mandatory subject of bargaining, and so it cannot be done unilaterally. But I would imagine that if you sit down in good faith with your union reps, there will be some understanding around the need to do that, particularly in the safety-sensitive environments. There's a question, of course, as to whether we'll see an increase in ADA claims by persons who may have a legal marijuana prescription. And in Ohio, we have under our workers' comp system something called a rebuttable presumption, meaning that the individual who is suspected to be using a substance and who's involved in a workplace accident, and if he or she is tested within 8 hours of the incident, the claim can be denied on that basis. However, the individual has the right at hearing to bring forward evidence as to the fact that, maybe they had a poppy seed bagel for breakfast and that's why they tested positive. But that's called the rebuttable presumption. So I don't think that rebuttable presumption is going away, but again, something to be careful of and to do your testing very, very promptly. So just to recap all of this, illegal use, asking about illegal use as far as applicants or other employees is not a violation of the Americans with Disabilities Act. Zero tolerance policies, drug testing policies in the workplace are completely permitted. Testing, completely permitted. Terminating those who test positive, permitted if your policy says that that's what will happen and you do it consistently. Job descriptions, again, I would urge you to go back and look at which ones need to be identified as safety sensitive. Those of you who have multi-state operations, please just be very mindful and work with your local councils elsewhere to understand what the drug laws and the requirements may be that impact your workplace limitations. Do be sure to train managers and supervisors. This is an important topic. Make sure they understand what your drug testing policy is about, what they should do when they observe somebody who appears to be impaired, who they should communicate with, whether they should let an employee just drive himself or herself to testing, and so forth. So do have some internal training around that subject. And also I would urge you to, if you do drug testing, advertise that. Make sure you deter people from coming in and applying to your company if they're going to be somebody that's going to pose some risk for your company.